Hi, my name is Stan.
My name is Connie.
My name is Judy.
My name is Aileen, and I'm a caregiver to my mother.
And I care for my mother, Octavia.
And I'm a caregiver for my mother.
And I'm a caregiver to my husband, Art.
I'm a caregiver for my wife, Ann, who's 72 years old.
Basically, I've done everything for providing for both of them.
I take care of my mother on the weekends. I take her grocery shopping.
Not only household chores,
I provide her medical care, coordination, driving, errands.
choosing meals, making meals, cleaning up.
I find that I take care of anything that he can't take care of.
Sometimes I find balancing time a real challenge.
The difficult part for me is taking me into consideration.
Balancing her needs with the needs of my family, the needs of my marriage, and my own needs.
Staying calm, nice, and positive.
The real challenge is, of course, the distance and the moment you get that last phone call.
What I love most about taking care of her is knowing that we're providing a secure and comfortable home for her.
It's the time we spend together.
Is the adventure of finding out new things all the time to trying to help him stay out of pain.
My name is Ed. I'm a spouse and I'm a caregiver.
My name is Colette. I'm a daughter and a caregiver.
I'm a caregiver, and I'm a daughter.
And I'm a wife and a caregiver.
I'm a daughter and a caregiver.
I'm a son, a nephew, and a caregiver.
Hi, my name is Debra Day, and I help manage United Way Caregivers Coalition. While caring for a loved one has its special rewards, it's a very challenging job. It can be stressful, overwhelming, and sometimes lonely. Each caregiving situation is unique, but all caregivers share the need for information and support. And that's where the Caregivers Coalition comes in. We help caregivers receive the support they need to take care of their loved ones and to take care of themselves. Caregivers who lead healthy, productive lives will be better caregivers. The most important thing to remember is that as a caregiver, you're not alone.
My name is Laurie Hauptman, and I welcome you all here to hear this talk. I'm an elder lawyer that has a practice in Livingston, New Jersey with my husband. I have been practicing in elder law and special needs law for about 20 years and find this a very fascinating and rewarding area of law. So I was thrilled when Debbie asked me if I could speak to you tonight. So the title of this talk is Everything Changes When Your Special Needs Child Turns 18. So what are the significant discussions that we can have today when we're beginning this dialogue? First of all, does anyone here know why 18 is a significant number or the age? Does anyone want to try to take a guess? Back there. It is of legal age, correct. In this day and age, believe it or not, with all the different changes of the laws and drinking age going up to 21 and things like that, it is still the legal age of majority. So 18 signifies when the law recognizes a child to make its own financial and medical decisions. Now we can have a discussion about whether or not that is all feasible in this day and age with children not lacking maturity, so to speak, or autonomy at the age of 18. And I always say that we don't live in Little House on the Prairie when Almanzo and Laura Wilder were having children when they were 15. So therefore 18 seemed very mature and they knew what they were doing and they were tending to a farm. That's not the case. But the law says at 18 we have to decide what happens to our children. And the reason we have to decide is because at that age, either the child is going to be able to make its own financial decisions, his or her, or you're going to have to step in and apply for guardianship. So that's kind of why you have to be aware of that number. And we'll go into more details about the guardianship and conservatorship and all that in a little while. The first thing I want to address to you is, if your child is high functioning, and I do have kids that I have worked with that have Asperger's and autism but are very high functioning, and if they understand the ramifications of the documents, they may not need guardianship. And it may be that their needs can be served by executing a power of attorney. So what is a power of attorney? A power of attorney is a document whereby a person appoints, they're the principal, appoints an agent to be able to make financial or medical decisions for them, with them and for them. So if you look on the PowerPoint presentation, you see that there's a financial power of attorney that we are speaking about, and there's also a healthcare power of attorney. A financial power of attorney takes into consideration any transactions that a person may need to do in the financial realm. So if someone has to be gifting, taxes, banking, filing insurance claims, anything that deals with finances, Medicaid planning language, even going into a safe deposit box, that's all under a financial power of attorney. A healthcare power of attorney deals with somebody appointing a person to be able to make medical decisions for you. Speak to doctors, access medical records, and then be able to make an actual decision. Don't confuse a power of attorney, a healthcare power of attorney, with a living will. So we hear it often that people say, oh, I have a healthcare power of attorney, and what they hand me is a living will. A living will is a separate document. Well, it doesn't have to be physically a separate document, but it accomplishes a different goal. And a living will is where, or another name for it is an advance directive, it's where you're telling your agent whether or not you want to be kept alive on advanced life measures. That is different than a healthcare power of attorney or a proxy in which you are appointing somebody to be able to make medical decisions. Now, if you look down there, it says combined directive. That's because, for example, the document that my law firm does, we do a combined healthcare power of attorney and living will, but they can be separate, and I've seen that. I don't tend to recommend documents in which I see the financial and the health combined together, but I have seen it. Also, if you look under the healthcare power of attorney, it does state that you always want to make sure that your healthcare power of attorney has the HIPAA language in it. Because if you have an old healthcare power of attorney and it doesn't have HIPAA language in it, your proxy or your agent may be able to make medical decisions for you, but they may not be able to access your medical records or speak to the doctors, and that really won't work, okay? So that's just a little bit of an overview, and we're going to kind of dissect it a little bit more. So a financial power of attorney, again, where you have a principal and an agent, is the document that we're speaking about. If your child has the cognitive awareness to be able to understand this document and the fact that they are appointing you as their parent at 18 to be able to help them with their finances and do any kind of transaction for banking, then they can enter into this agreement with me. I can fill one out on their behalf, okay? The difference, though, is that they have to have some cognitive awareness of who all the players are, obviously who you are, which I'm sure they would, and whether or not they want the assistance. So often, I am able to resolve that concern that parents have about being able to do transactions for their kids when they turn 18 through a power of attorney, which is a lot less costly and a lot less invasive than a guardianship. A power of attorney can be springing or immediate. Who wants to take a guess at what a springing power of attorney is? A springing power of attorney comes into effect upon a certain event. So, for example, you may say that if I'm out of the country, then my power of attorney comes into effect, okay? And an immediate power of attorney is the one that we often do, where as soon as you sign it, then your agent has the ability to do all the transactions that you can do. It doesn't eliminate your rights to do them. It just gives them the ability to do them as well, okay? The financial power of attorney, we also get asked who should have one. Everyone over the age of 18 should have one. Now I'm going to do a little bit of a test in this room just to kind of wake you up a little bit. How many in this room are married? And of the ones that are married, how many of you have a power of attorney? Okay, so the ones that are married, I want to ask you something. Do you have any IRAs, or does your husband have any IRAs or 401ks? Do you? Okay, you do? So I want to ask you a question. I'm not putting you on the spot, but it's a really important point to get across. How would you enter into or get into your husband's IRA or 401k if you did not have a power of attorney?
Because I'm the beneficiary.
Yes, that is true, except what has to happen for you to collect as a beneficiary?
He has to pass on.
Correct. So that's really the problem that we see. Everyone thinks that as long as you're a beneficiary and a husband and wife don't need these documents, they're wrong. Because the beneficiary only comes into play if they die. But most of the times, the reason why you would be needing to enter into your husband or wife's IRA or even your child's assets is because either they've been injured or sick, and then the beneficiary clause doesn't come into effect. Do you understand that? So everybody, including husbands and wives, need to have documents with each other. And this is a big misconception. If a husband and wife do not have documents, and I see it all the time in my senior elder law part of the practice, and the wife needs to access the husband's IRA or vice versa, if they don't have this document, they have to apply for guardianship. Okay? That's a big awakening, because a $300 power of attorney now turns into a $6,000 to $8,000 guardianship. Okay? So that's just a little bit of an explanation about the fact that we as husbands and wives get lulled into a sense that as our marriage certificates permit us to do certain things, they do not allow us to bank or do financial transactions for each other on accounts that are not joint. Okay? So when I say who should have a power of attorney, I mean everyone, and everyone over the age of 18. So I also want to comment about the fact that even if your child is typical, okay, they need one as well. So my child is 20, and he went to college in Pittsburgh, and he had to go to the emergency room. I'm not even talking about the healthcare power of attorney part. He had to go to the emergency room in Pittsburgh, and he had a bill because they don't care who pays. And I called up to find out how much it was or information about it, and they said they will not talk to me. That's for a bill. I didn't ask him about what his diagnosis was, even though I knew what it was, because I'm his mother. But I just wanted to know about paying the bill. No, my son is over 18. He incurred the bill, and they would not release any information until I sent them a power of attorney in order for them to speak to me. So this is the world that we live in, whether or not your child is typical or atypical, and this is what you have to protect yourself. We are in a post-9/11 Patriot Act world. You cannot get information for anyone anymore, including your husband and your wife and your children, okay? If your child is under 18, then they are legally, you are their guardian. So this is not an issue under 18, only over 18, okay? The healthcare directive, again, you see what I put up there. Healthcare power of attorney is another word for proxy, and a living will is an advance directive, okay? We do a combined one. This document, again, addresses the health, and everybody, again, over the age of 18 should have one. Does that mean that if you took your child to the emergency room and they were 19 or 20, they wouldn't talk to you? They may, but I can tell you that when my son did go to St. Barnabas when he was 18 and a half, and you kind of lose track of this, they did not even talk to my husband and I. Now, he was able to say to them that my parents can listen and ask questions. But if he was not conscious, or he went into a state of unconsciousness, I at that time did not have a healthcare power of attorney, and I was therefore not appointed as his agent. I would have not been able to legally make decisions for him. So do you see, I'm trying to explain to you the illustrations that we see whether or not your child is typical or atypical. Okay, so that's a little bit of an overview of the documents. Now, if your child can understand about their health and you feel that they would ask you for guidance, and that they would get the blood work when they need it, and that if they had a stomach ache, they would want to go to the doctor, and if you feel that they are compliant like that, then we would, regardless of whether or not your child has a diagnosis, autism or Asperger's, Down syndrome, if they can understand the ramifications, then they can sign that document and you can be able to make decisions for them if they can't. But I want to explain one thing about that though. If you are their agent under their power of attorney, they still can make decisions as well. So if you are worried that your child at age 18 will sign a credit card application and charge up a huge amount to buy equipment or to buy a car or whatever, you don't know what they're going to do, I cannot get them out of that because they are legally allowed to do that. You can also do that with them or for them, but it does not declare them incapacitated, so they are legally responsible. So if you are concerned about that, then the power of attorney would not be the route that we would go. So for example, I had a parent that said to me, I have a child that would never want to sit for a blood test. So they will say no, and if they're over 18, guys, I'm going to tell you, this is the truth. If you take them and they're over age 18, and you bring them to a phlebotomist, and they turn to the phlebotomist and said, I am not giving blood, the phlebotomist cannot force them to give blood. And that is why that scenario would result in you needing to have applied for guardianship. I do have a case where a parent was or felt that their child would make medical decisions with them and wisely, but their child had a trust fund. And so they were concerned about the child having power with regard to the assets that were in the trust fund. And so in that case, we did a healthcare power of attorney, but we did a conservatorship, which I'm going to explain in a minute, that dealt with handling the money. Okay, so it's a case-by-case basis that we work with as lawyers. We don't do one scenario for everybody in this room. So we have a dialogue. Tell me about your kid. So I would say, Jennifer, tell me what your child and what the situation is with him or her. And we sit down and we talk about it. Because it is a case-by-case basis that we're going to make the decision. Can we use the documents, or do we need to line up guardianship? Okay? But I do want to make you aware that it isn't only guardianship. And that's why the title of it was, preparing for it is deciding and making these decisions. Okay? And also, if your child is young, you can't make this decision yet. If your child is only 5 or 6 years old, we don't know what their cognitive abilities are going to be, and we don't know what their judgments are going to be, and we're not sure where they're going to be at with regard to ramifications of understanding the nature of illness or finances. So it's a little bit sometimes too early to judge that. And that's why we would regroup when they got closer to 18. Now, guardianship is the legal process that we work on or a proceeding when an adult child comes of age, turns 18, or I do it with my seniors that are losing cognitive abilities. Let's talk about the guardianship process, okay? So you feel comfortable and understand what we're talking about. Guardianship is a legal proceeding where you are asking for the court's intervention to appoint you as a guardian. So whereas the other choice that I gave you is a document that your child is executing with me to appoint you, this is the opposite. You are instituting this proceeding in order to have powers over your child, okay? So it's a little bit of a different dynamic. So a guardianship, in the case of the guardianship, I am usually retained by the proposed guardian. So if you in this room wanted to do guardianship for your children, I would be representing you, okay? And in that case, we would file a complaint. It has to be actually a formal legal complaint. But before we do that, we have 2 doctors that examine your child. And they have to determine whether or not your child has capacity and is able to make financial and medical decisions for themselves. And if they can't, then the child is deemed incapacitated. So I want to just stop for a moment to talk to you about this. This is a very emotional area of law, and it's a very emotional determination. But I want to embrace all of you to understand this. This is not a diagnosis that is set in stone, and I want you not to be hung up on the fact that a determination of incapacity has to be made for this time period. I want you to embrace the fact that it's an important stepping stone that you may need for a time period, but to not feel that it's a sentence. I want to explain that to you because I understand as a parent of 3 children that it's a very emotional part in your life or time in your life when you have to get this diagnosis, because it feels either 1, that you're making a diagnosis that is set in stone, or that 2, you failed in getting your child to a place that you wanted to be. And I don't want you to feel that way. The law says that at 18, you have to put these protections in place. Your child can grow and gain cognitive abilities after 18, and the guardianship can be undone. But I don't want you to go without having the protections at 18 in place. So are you guys following me what I'm saying? And by the way, they used to say incompetent, and now we don't say incompetent, we say incapacitated. But I understand that that sounds like a harsh word to you. But I want to explain to you it's a legally word that we have to say. But I embrace you, or I impart to you, to just understand that this is what needs to be done to set this in motion. Okay? So I represent the guardian, and then the court will appoint an attorney to represent your 18-year-old child. I can't represent both of you because there's an inherent conflict of interest. Your child has to have his or her own attorney in order to make sure that their interests are covered. Now, would I tell you that 99.9% of the time, I am never going to have a parent that's interest is not the child's, but the court has to be involved to make sure that in case you have that, 1 in a million set of parents that may want to take advantage of a situation or make a determination that's not appropriate, that we have a lawyer watching out for that child. We have to appear in court, and there is a cost involved. So the average guardianship cost around $6,000 to $8,000. So, and that's with all the fees. So my fee, usually the guardianship part is about $3,000, from the lawyer, but then there's another lawyer involved too. So again, it ranges depending upon if there's contesting. If somebody steps in and says that you aren't the appropriate guardian, it gets more involved. If the child actually contests it, which usually that's not the case with my children, but it may be with my seniors. So it really depends. But on average, my children's turning of 18 guardianships, they are not usually contested, and they do keep in a lower range, okay? I want to explain to you that once you do become guardian of your child, you are required to report to the court every year about your child's well-being and any assets that you are managing for the child. And that is the oversight requirements that are in court. It's a form that you fill out and send No one comes from court to check on you, but it is a requirement that you do annually, okay? Now let's talk about why guardianship is a little bit more of an invasive proceeding. Because when you apply for guardianship, your child will lose his or her civil rights unless we carve those rights out and they can keep them. So let me ask you this. What are the civil rights that your child can lose if you don't go see someone, first of all, that knows this area of law and also doesn't know to do a limited guardianship? Does anyone know what civil rights your child would lose in guardianship if we didn't take the next step to bring them and keep them? Your child can't drive, can't vote, can't marry. Okay? Now, you should all go that, damn, yes, I heard that back there. But that's why, that's okay, I want you to feel that way. But that's why we would do a limited guardianship where we would put in place the mechanisms to protect your child to be able to, so that you can make financial and medical decisions, but they can still keep their right to marry, to vote, or drive. Look, I have Asperger's children that know more about politics than I do. They should be able to vote. Or if you have a high-functioning Down syndrome child, they should marry. But so we are progressive in keeping these rights, but you have to go see a lawyer that understands that you have to carve these rights out when you're filing for the guardianship. And there's no reason they can't drive. Now, sometimes I will tell you that I have parents that tell me, I don't think my child is ready to drive. That's okay, but that should come from you, not that the court takes it away from you. Okay? So that's what's called a limited guardianship. And you can also even carve out rights. I did one recently where we carved out that the child can spend a certain amount of money without having to ask. So there's lots of ways to make this a progressive proceeding. Okay? So a guardianship, by the way, is a comprehensive proceeding where you're making decisions over the body and over the property. Okay, did you hear what I said? Body and the property. If you feel that your child does not need a guardianship over her or his body, because like I said, they would be able to execute a healthcare power of attorney, or they would understand medical ramifications, and you are only worried about assets and property, you can do a conservatorship. Okay? So I'm going to explain the difference. A conservatorship is also used when an adult child is coming of age or a senior is losing cognitive abilities. But the difference is in a conservatorship, where in a guardianship where you are hiring me to be to start the proceeding because I'm representing you as the guardian, in a conservatorship, the complaint is actually brought by often either your child, who is already 18, or by you, but with the permission of your child, okay? And I represent the conservator, and the court may appoint an attorney for the conservatee, but most times they don't, because it's less adversarial, because it's voluntary, okay? You do not lose any civil rights with a conservatorship. There is no determination of incapacity, okay? You do not need physician exams most times. But you do still need court appearance. Well, sometimes they waive a court appearance, but sometimes you still have to appear. And unfortunately, the cost is somewhat similar. Because doctor's exams actually really don't cost most of the times money, because most of my clients use their neurologists or pediatricians or psychiatrists or psychologists, and most of them don't charge for the report. If they do need a examining doctor, for example, they need 2 and maybe they only have 1, and then there may be a charge, and it usually ranges in the area of $250 to $500 for the report and the paperwork, okay? So conservatorship, I just did one the other day because I had a boy that had a trust fund, and it was a lot of money, close to about $400,000. So he actually hired me I have to tell you, most of my kids that I do these documents for or conservatorships, they go around telling all their friends that they have an attorney. I have an attorney, and they're all excited about it. So in that particular case, I was hired by the child, the young man, I should say, at 18, and we did a conservatorship. And he understood, and a conservatorship comes into play when they are concerned that they're going to be taken advantage of. So where they could be sort of sold the Brooklyn Bridge, so to speak, and this is what you're protecting, okay? So that's kind of where that comes into play. Okay, so let's talk about some estate planning issues with regard to special needs kids. We often see these mistakes, and so I always like to educate you about them. So the first thing we see when people are doing estate planning, and when I'm talking about estate planning, I'm talking about when you're preparing your wills and how to think about what the next stages of your life are with regard to your children. So many people think, well, they have to disinherit the special needs child because if this child comes into money, everyone is of the mindset that then they would lose their benefits. But that's not the answer. You don't have to disinherit your special needs child in order to protect them, okay? Because that child is likely going to be the one that needs the money, possibly more than your child that does not have special needs, okay? Another estate planning mistake that we see is leaving a greater share to another child to take care of the child with special needs. So if you have two children and one child is typical and one child is atypical, to give the child that is typical a greater share with the understanding that they will take care is not the way to go. First of all, you could leave it to a child that eventually gets married. You're talking about your non-special needs child. And once they mix that asset into their marital funds, I can tell you right now, and I've seen it, if they ever got divorced, that wife or husband will never remember that that is what you did it for, and you will lose that money, okay? If that child that you gave the greater share to in hopes or that they were going to take care of your other child gets into trouble with the law or gets in trouble with bankruptcy, you will see that money go as well, okay? So it is not the way to do it. And we've seen it, and this is why I'm able to tell you, okay? Another estate planning mistake that I see with my children with special needs is leaving assets outright to the child with special needs. So that's a big problem because if your child eventually goes on government needs-based benefits, so where the benefit that they are on is calculated by either income or assets, and you provide them an inheritance, they will have to lose that benefit. They will come off of it, have to spend down whatever you left them, and then go back on it. There is an alternative to that, and so you don't have to do it that way, okay? The next estate planning mistake, and everyone, I want you to ask questions if you have any while we're talking. Leaving the assets to a general needs trust. So how many people in this room have a will that you set up, and in your will you had a minor trust, or it's a cascading trust of years for all of your children? So I have that, for example. I do not have any children with any special needs. I have a nephew with Asperger's, and that's sort of what got me in this area of law. But my children do not come into money if my husband and I pass away until they reach 23, 26, and 30. So that's a trust, but it's called a minor trust. And that trust doesn't have any bearing with regard to whether or not your child has any cognitive impairments or abilities, but it goes by just age intervals. Again, let's go back to what I opened with is we don't live in the Laura and Almanzo Little House in the Prairie time. I don't want my 18-year-old coming into money because he will not understand what the money is to be used for. Maturity level at 18 is not there. And so at 23 and 26 and 30, there are intervals that you are distributing. And by the way, if you have a minor trust, you understand that that just means that that's when the child automatically gets their money. They always have access to it through a trustee, but they can't take it out automatically, okay? So that means that if you ever set up a minor trust, for a little bit of a side note for all of you, and your child says, hey, mom or dad, this man named Bill Gates approached me about a potential investment, and again, I'm flashing back before all of that came into being. And if you went to your trustee and said, I'd like to invest in this new thing called, Apple, then your trustee could still release the money to you, but it had to be at their permission. It's the 23, 26, and 30 just means that that's when they get their distribution without questions asked about what they're doing with it. So what I say about the mistake is parents do that, but they think that that takes care of their special needs child, and it doesn't. If your money is put into a minor trust, they will still lose their government benefits because the minor trust does not have the language in it that it needs it to be compliant with keeping your government benefits for your child. Okay? So do we kind of follow that? The minor trust is important, but it doesn't satisfy the issues that we need to protect the government needs-based benefits that your kid can be on. Now, does anyone understand the difference between a needs-based benefit and a regular government benefit, a non-needs? So let me ask you this. How many in this room thinks that SSD, Social Security Disability, is a needs-based or a non-needs-based? How many think it's a needs-based, SSD? How many think it's needs? Okay, and how many think it's non-needs? Okay, so SSD is non-needs. It means it doesn't matter what your assets are. Trump can get SSD. That's Social Security Disability. It means you have a disability that makes you unable to work. It doesn't go by what your assets, and it does not go by your income. Anyone can get it. But SSI, Medicaid, PAD, HUD, all of those are government programs that are needs-based. They only come into effect if you comply with having certain assets and having certain income levels. And those are the benefits that I want to make sure that are protected if your child comes into money. Okay, so do we kind of understand a little bit about what we're speaking about? Okay, so let's talk about how we do that, how we protect money, and what we want to do in your wills. So the first thing I want to explain to you is, if you are drafting wills, please do not go just see your local general lawyer in town. If they do a will for you, and they do, even if they understand that you have a special needs child, and they'll tell you, well, I'll do the wills for you, and then later on you can add the special needs trust or other documents, say thank you, but I'm going to go see someone that can do it all at once, because you will be redoing it. I had a client come to me. They had all their documents prepared, and the lawyer said, well, I know you need a special needs trust. I don't do that, but let's just do all your documents. And then a year later, I redid them. Now, they happen to be wealthy, and that wasn't as much of a significant issue for them. But that's not the case with most of my clients. So that's a shame. So if you're doing your estate planning, your wills, your powers of attorney, please see someone that understands special needs law as well, okay? So an estate planning lawyer may understand your estate planning, but they may not understand your special needs law, okay? The reason I'm telling you this is because in your wills, and when you're drafting your wills, that is the opportunity for you to leave money to your special needs child and protect them from still being able to collect government benefits in the future, okay? So let's put our little bit of our special needs elder law hats on, and we're going to learn a little bit about the two trusts that we use, okay? A third-party trust is a trust that is set up from assets from a third party, exactly how it sounds. So, when you are setting up your will and you are leaving money to your children, so I leave money to my son Andrew, and I leave some money to my other children, I set forth who I'm leaving it to. If I have a typical child, I can leave it in the minor trust, which we talked about a second ago. If I have a child that's already emancipated and I'm not worried about a minor trust, I can leave it outright. And if I have a child that has special needs, I leave it to a third-party special needs trust. I actually write in the will that Andrew's share goes to the Andrew Hauptman Special Needs Trust. That's how it's done. Assets are protected for the child, but he or she can still qualify for the government benefits. So if I die and my child comes into $500,000 into that trust does not prohibit that child from keeping their SSI, their Medicaid, their PAD, their HUD. Do you understand? Okay? Now, when you die and your assets pass into a trust, that's what's called a testamentary trust. You are funding it upon your death. Are you all following me on that? Okay? An inter vivos trust is when you're setting it up with money while you're alive. And you could do either or. You could come to me and say, I want to set up a trust now, and it's not from the assets in your trust. From your will, upon your death. So it depends on what your needs are. Are you following me? Who said no? Oh, you want to see the difference? So an inter vivos trust, which means inter vivos means living, you can come to me and say, I'm having a good year, Laurie, and I have about $50,000 of surplus. I would like to set up a trust. So we would set up a trust, we would prepare a trust document, and then you would take that $50,000 that you have in your bank account, your TD bank, and put it into a trust. And that didn't happen because you died. You just had $50,000 extra. It's an inter vivos setting up of a trust because it happened while you're alive with money that you have. Well, no, that's a separate subject. It's not talking about investing. I'm just saying the difference between funding a trust upon your death or funding a trust from assets while you're alive. That's just describing a testamentary trust or an inter vivos or a trust while you're alive. Okay? I can talk to you afterwards to explain it. So, in essence, it depends on how you're doing it, or you can do it both ways. Okay? So, the reason why most people want to change their wills and deal with the funding of a trust is because that's when they're going to have the money. Most of my clients are struggling day to day with special needs children and the cost of special needs children. They don't have the extra surplus until they die. So most times the special needs trusts are not funded until they die, because that's where their assets are going to come from. So the idea is, when you're preparing the wills, that's when you're directing where your money goes, and that's when we're talking about the trust. We're setting up a physical document that says trust. Now, I think what people don't understand, and maybe this will answer your question back there, what is a trust? So people get confused about what a trust is. So think of a trust as like a fictitious person. And just like me, I can own a bank account, I can own stocks, I can own a home, I can own a mutual fund or money market, I can own stocks. A trust can own all of those things. So a trust is a fictitious entity that you've established. So it can be a bank account, as you just asked me. It can be a physical bank account where you go in with my trust document and you say to TD Bank, can you open up a checking account in the name of the trust? Or you can have stocks and you can retitle stocks in the name of a trust. So it's many of those things, okay?
Is it irrevocable or not?
Okay, so that's a very interesting question. So the trust that we set up, the third-party special needs trust that we set up, are revocable, but up until a point in time where it becomes irrevocable. So they're revocable because, for example, the scenario I gave you, so just say you did your wills, and in the will it says that my son Brian gets his money pursuant to the 23, the 26, and the 30, but my son Andrew gets his distributed to the special needs trust. Okay, so we're kind of familiar about how the language of the will would work. So it's set up for when I die, but just say I have a good year. We put the will aside, okay? And I want to open up and give $50,000 and put it into a trust account. Remember I explained, I have the physical document because I prepare a separate document at the same time as I'm preparing the wills. So we all following me? I have the will set up in case you die, but just say you had a good year and you wanted to go to a TD Bank and open a trust account. You can use your money to open up a trust account and it's revocable, okay, for a period of time. Meaning, if you then have a bad year the following year, you can go to TD Bank and take that money out, even though you earmarked it for your special needs child, but it's revocable. Are you all following me? But depending upon what we would discuss in the law office, we tend to make them irrevocable after a series of events happen. So I'm going to give you an example. So it's revocable while we were talking for the next few years, but just say your mother dies and she leaves your child money, and we tell grandparents about this trust, by the way. We don't just work in a vacuum when we do special needs planning. We tell all of you that if any of your relatives want to leave money to your special needs child, they should refer to this trust as well. Because if they come into money, well, you took care of it on your side, but then they come into money from somewhere else, it will defeat the purpose of the fact that they'll have to come off their benefits. So just say your mother leaves your child money, and then the money gets dumped into the TD Bank account, then you will not be able to get your money out once that event happens. Okay? So it is revocable up until certain points, and then it becomes irrevocable, which isn't a bad thing because it's still for your child. Okay? So is everyone following that? Now, why is third-party trust so important? Because a third party, and listen to me guys, if you set up a trust and you fund your child's money from a source other than your child's own money, there is no lien, listen to me, no lien that will be asserted by the government for benefits that they have paid out to your child. That's a biggie. Because I'm going to tell you what the next one is, so you walk out of here understanding the difference between a third-party special needs trust and a first party. And by the way, it's in your pamphlets, all of this written out. So when does a first party come into play? So a third party, we already talked about, comes into play really in your wills, or if you have extra money, your own money, to give to your child, or a grandparent has money. But when does a first party special needs trust come into play? Well, just say your child was injured, and that's how they became disabled. And they came into a lawsuit money, okay, and they see maybe $400,000 in a lawsuit, okay? Or they had a medical malpractice case, or they had I've had Social Security back awards, and they come into a lump sum. Well now, where is the source of the money coming from now, guys? A first party or a third party? Which one? Who's the money? Whose money is it that's going into the trust? Whose? It's the kids. It's the person's. That's the difference. Remember, before we were talking about a third party special needs trust because it was funded by a third party. And we like those. Why did we like those? There was no what? Lien. There was no lien. But if your child comes into the money and then they put it into a trust, there is a lien. Okay? So if the inheritance that your mother, that we just talked about, if your mother had money and didn't put it in her will, so it came to him upon death from her, but instead she put his name and it came to him first, and then he had to put it in, it's now a first party. And then now there's a lien for government benefits that are paid out over his lifetime or her lifetime. So that is why it allows you to keep the money and the benefits, but otherwise you have to pay back whatever's left over in that trust. So what I do tell my people that have to do first parties, because just say they came into the money, It wasn't something we could do from a third party. I tell them to use it, because if you don't use it, you lose it. So, okay? Now, what does the special needs trust money used on? It uses it to enhance the quality of your child's life. It is a way to equalize what your special needs child will want in his life that he won't be able to get by getting government benefits. In the days before they did this, if your child was on government benefits, he or she would only get money to pay for rent and food, heat, the utilities. But where was the quality that your other child, your typical child, could have? The beauty of a special needs trust is it allows them to get a government benefit that pays for those non-frivolous items and allows your child to get the frivolous items that he or she is entitled to. Do you understand? So what am I saying? What's the examples that I want to give? So if your child's money is in a special needs trust, the trustee, who is going to be you likely while you're alive, can buy a stereo, can buy a computer, can pay for furniture for an apartment, can pay for a housekeeper for the apartment, can pay for a trip for your special needs child, can pay for a car, the expenses of a car, can pay for, maintenance of lawns. And so many things. Why is that great? Because all of that money can be used and the child still collects the government benefit. Okay? So it's an amazing situation that we have, and so that's why we want to put the money. If you don't have a special needs trust and your child comes into money, then what happens is the government says you have to come off the government benefit, spend down to the $2,000 or whatever the level is to get it back, and you can go back on. But why? Why not take the government money and use the trust money to enhance your child's life? Okay? So these are the beautiful choices that we have by doing special needs law. So just a little bit of tidbits, and then I'll answer any questions you have. So when do you need to gear up for guardianship if you have a child that is reaching 18? I would say that you should start filing for guardianship or gearing up with a lawyer several months before, 2 to 3 months, because you want to make sure you have a court date very soon at the time when the child turns 18, because you don't want to be in the vulnerable situation where your child is 18 already and you have nobody making decisions. So imagine that you didn't come see me early enough, and then the child's sitting in that phlebotomist chair for blood work because they're on medication, and we can't force the situation. Okay? So you want to gear up about 2 months before. If your child is going to execute documents, we can't do those documents until your child reaches 18, because they are not legal. And remember, you want to do those documents whether or not your child has special needs or not. We just discussed that. So my 20-year-old has these documents, and my other child is reaching 18 in a few months. If anyone ever has a child in college and you try to call the college to find out anything about your kid, they will not tell you anything. Grades, anything. The reason is your child is emancipated. I personally, and Debra and I talked about this recently, think it's crazy. We pay the bill. We pay the college bill. They don't care. They don't care that you pay the college bill. Your child is legally emancipated, and you are not entitled to any information about that child. So she asked, what kind of diagnosis do you need? So you just have to you can't just say you're special needs. Well, actually, in terms of a special needs trust, you don't have to have a formal diagnosis in terms of, you can be Asperger's and autism. I've had people with Down syndrome, bipolar disorder, depression, schizophrenia. Those are all reasons why people set up special needs trusts. The government doesn't oversee this. There's requirements that the special needs trust has to have, but in terms of a third party, when you're setting it up personally, they don't oversee the diagnosis. If I was doing a first-party special needs trust where I'm asking for the court to intervene, then you have to be deemed disabled by Social Security. Okay? That has to be a Social Security diagnosis. But when you're doing it for your child, for just the third party, it could be for any reason. I filed for guardianship. It takes about 2 weeks for the court to put in the paperwork and file the order to show cause, and give me a date. And they contact an attorney right away. So within 2 to 3 weeks of filing, an attorney for your child is appointed. And then the court-appointed attorney has to contact you. And what I do is, since I'm really working with the family, if my parents haven't heard, I get on the phone to the court-appointed attorney and say, why haven't you called? It's very non-adversarial when you're dealing with this kind of a guardianship, because what I'm going to do is, I'm going to arrange everything. Like, you're going to have your child served when you're there by, because it has to be official. And we're going to work together on that. And the court-appointed attorney is going to make sure you're there when they're talking to your child. It's not to be scary. It's made to be very friendly. Okay? Everything I told you here applies to both my areas of law. I'm an elder lawyer and I'm a special needs lawyer, and I use both of them equally. So I did a conservatorship not too long ago of a senior that was we wouldn't say was incapacitated, but certainly would probably get scammed in a second. So we took her ability to be able to access her money voluntarily by doing a conservatorship over her. My father's 82, and I want to tell you what happened to him the other day. He got called by a kid or a woman that was disguised as a voice saying, Grandpa, I'm in trouble. I just had a car accident, and I just been arrested, and I was drinking, and I got a DUI, and I'm in jail. And my father said, Emily, and that's my niece. And the person goes, yes, it's Emily. And my father said, what happened? Grandpa, I made a big mistake, and I'm in trouble. And my father tried to get a hold of me, but I was in a client meeting, and he didn't know what to do. He tried to get a hold of his granddaughter, who's 23. She was busy because she didn't answer. So what did my father do? And then, by the way, they were very sophisticated. They then got a lawyer a guy on the phone who said he was a lawyer. I can handle this. I happen to be in the jail, in the police department, and I can represent her. Please wire me $1,800. Guess what my father did? He went to his bank. He took out $1,800. But thank God, he then got in touch finally with my niece, and she said, hi, Grandpa, what's the matter? And he said, Emily, are you arrested? And she said, no, Grandpa, I'm sitting here in Rockaway, New Jersey. So that's an example of what happens. That was 2 days ago, guys. I don't make this up. And that's a very common scam that's going on, but you think that you know enough of these scams, and every time you turn around to know a scam, there's another one. So I do those conservatorships, so for example, that person couldn't access the bank. Thank you so much, Debra. Thank you so much for having me. I want anyone that wants to stay after and ask me some specific questions about my law firm, I'd be glad to, but this was more about educating you just generally.